can you protect your assets from creditors by way of a declaration of trust? Well, the answer is pretty much nope. But you don't have to take my word for that. Let's look at the evidence. So here we go. Case out yesterday. You can see about 30th of July 2025 between the trustees in bankruptcy and John Charles Dixon and Janet Marie Dixon. This is a case in which the trustees in bankruptcy brought an action against the respondents under Section 423 of the Insolvency Act 1986, which is all about putting assets in effect beyond the reach of creditors. Now, Section 423 is about transactions on undervalue. In other words, the asset has a value, it gets transferred to somebody else, and effectively the party who had the value has now got none of that value anymore because of the asset being transferred. And this is exactly what Section 423 is designed to prevent. And we can see above where the judge says to satisfy Section 423, it's only necessary to establish that putting assets beyond the reach of a person who is making or may, that is critical in this case, may make a claim or otherwise prejudicing the interests of such a person in relation to the claim which he is making or may make was a purpose. It doesn't have to be the only purpose. It does not have to be the sole, substantial, or dominant purpose in relation to the transaction. Now, what a lot of people do when they're faced with a Section 423 claim, not that there's that many of them, but when they do arise, ultimately what happens is somebody will say, well, when I did the transfer, I had plenty of assets, I had a great income, absolutely fine, and even after I transferred the assets, I was still okay, and I had a good income stream, and so on. And critically, the creditor who has come along to make, in this particular case, the individual was made bankrupt, but when the creditor comes along, they were not a creditor at the time that the asset transfer took place. And this argument fails to work if the purpose, not necessarily the dominant purpose, but if the purpose is to put assets beyond the reach of creditors. And what the court said was that the class of victims, as defined in Section 423(5) of the Insolvency Act, is not limited to those who were within the compass of the transferor's purpose when entering into the transaction. And then the court goes on to say all that is required is that the claimant is prejudiced by the transaction. There is no statute requirement in Section 423(3) of the Insolvency Act 1986 for the transferor to have had any particular knowledge of the persons making a claim or who may a claim at the time he entered into the transaction. Now, this is the key issue, is the discretion available to the court. The court has a very wide discretion in terms of the relief, which should be exercised to achieve restoration to the extent appropriate to protect the interests of creditors. So the court is clearly alive to the fact that if somebody engages in a transaction and there is some problem later where their creditors will not be able to essentially hoover up those assets in repayment, that basically the interest of creditors is fundamental. And what was quite interesting in the Dixon case is that Mr. Dixon, who was actually a former managing director, head of UK tax at E&Y, which is one of the biggest accountancy firms around, he essentially took advice before doing these declarations of trust in relation to various assets. And there was a file note that was presented to the court about, and this gave some sort of indication as to what the motivation behind the transactions and the declarations of trust was. And it says that John advised that the nature of his call was to discuss the asset ownership between himself and his wife. John had been speaking to his fellow partners at E&Y, and it appears that many of them own assets entirely in their wife's name. This is really a method of asset protection to try and to avoid those assets being susceptible to attack by creditors. John asked for general options available to him and his wife to try and safeguard this in view of this high-risk business. However, ultimately, Mr. Dixon was made bankrupt on the back of claims from HMRC, And the court made a note of his generous income and that he'd failed to make a payment on account to HMRC for in excess of £300,000 in respect to the tax year 2012-2013. And when he left E&Y, he was given some generous income thereafter. But yet, the court noted, notwithstanding receipt of these significant leaver payments, Mr. Dixon did not pay the sum of £300,000 due to HMRC. And as far as the file note was concerned with the solicitor about the declaration of trust, the court placed considerable weight on this and said, considered in the context of the file note, read as a whole, in my judgment, the purpose passage speaks for itself. This is the key point that the court made, that in executing a suite of declaration of trusts, Mr. Dixon plainly intended to render himself judgment-proof. The court, in assessing the matter as to the situation concerning the fact that HMRC was not a creditor at the time the declarations necessarily were ultimately being undertaken, or wasn't the major creditor of him at that particular point in time, the fact that the ultimate claimant was not in the contemplation of the transferor at the time of the transaction is immaterial. The class of victims as defined in Section 4235 of the Insolvency Act 1986 is not limited to those who were within the compass of the transferor's purpose when entering into the transaction. And we can see here the result. For all these reasons, on the evidence which I've heard and read, I am satisfied that the trustee's Section 423 claim in relation to each of the declarations of trusts is made out. So ultimately we can see there, you cannot transfer assets out of your hands into the hands of another, such as your wife, as in the Dixon case, and do so if the potential issue or the purpose behind it, even if it's not the only purpose, was to put assets beyond the reach of creditors. Questions, queries, concerns, give us a shout. We know insolvency inside out.